Good afternoon, everyone. This is Kenya Rahman, the founder and author of The Child Support Hustle. I hope everyone is doing well this afternoon. Let me cancel that. Wait and see if we can get people in real quick so I can discuss what I need to discuss. I haven't been on in a while, but I've been posting as much information as I can. I just wrote a blog and I posted it this week, I think, about, and I went over the reform, if we can call it that, out of Ohio. It's posted now on childsupporthustle.com. I'd like to get your thoughts on it. I don't call it reform. They've made a couple of changes. Reform is a stretch, but if you'll read it and let me know what you think, I would like to get your opinion. Just because they say they reform something doesn't necessarily mean that's what it is. So let me know what you all think. First off, again, thank you all for your continued support. I know this fight has been long and difficult. It doesn't seem like we're doesn't seem like we're getting anywhere, but we are. There's a lot of shared parenting legislation going on. I know Kentucky just passed legislation for shared parenting. And Jason Griffith, I hope I just pronounced that correctly, was very instrumental in getting that bill passed. So I know some other states also have done that. So there's a lot of positive things happening. So please don't give up. Don't get discouraged. This is a multi-billion, some would say trillion-dollar industry, child support, family court, the industry. So they're not going out without a fight. So don't be too discouraged. Let's just keep going and let's just keep fighting, guys. Before I get started, I want you all to know that the Child Support Hustle team will be at the 13th Annual Block Party for Peace town hall. Well, we're not having a town hall, it's a Block Party for Peace event in Memphis, Tennessee, September 28th through the 30th. And there's a bunch of events planned. It's hosted by State Representative Antonio Parkinson. Congratulations on his reelection. And the address for the event is 3385 Austin P Highway in Memphis, Tennessee. It's going to be from Friday to Sunday, 10 a.m. to 6 p.m. We'll be there for sure on Saturday. If you want to come down and buy a book, buy a t-shirt, make a donation, come down and meet us if you need some information about child support, whatever information I can provide you, I will be more than happy to do so. If you just want to come down and enjoy the festivities, please do so. He has a lot of vendors there, a lot of entertainment there. It's kid friendly, everything like that. So please come on out, Memphis, or if you're in Tennessee, period, and just want to come out and have a good time, please come on. Now, this rescinding of the DOJ letter. Hey Chuck, I found out that, okay, let me start from the beginning. The DOJ released a letter under Attorney General Lynch, and the letter talked about they couldn't use debtors' prisons as a means of punishing people. You couldn't afford to pay a debt. This went further than child support and them locking people up if they couldn't pay child support debt. Suspending licenses, hey Sean, because people couldn't afford to pay the debt. This was all that was in this letter. The letter goes beyond just punishing poor people or child support. And I did a video about it. I did a video about it. And like a week and a half after I did the video breaking down this letter, Lynch had, moved on. The administration had changed, and Attorney General Sessions was in office. So I did a video breaking down this letter and letting people know what they could and couldn't do, which is in the Constitution. About a week and a half later, December 2017, Attorney General Sessions rescinded that letter. And I made a video discussing the letter again and him rescinding that letter. And of course, I wasn't the only one pissed off. A lot of people was pissed off. But I discussed it, letting people know the information that was in the letter, because it went beyond, like I said, child support. There were a lot of case law, a lot of constitutional references in there that people could use if they were being incarcerated or license suspended because they couldn't afford to pay. Well, I didn't even revisit that because, you know, I always reference Turner versus Rogers, and that was when the Constitution, I'm sorry, the U.S. Supreme Court made a decision based on a parent who was incarcerated several times for non-payment of child support when he couldn't afford to pay. So I made the video and I moved on. A couple nights ago, a gentleman I don't know had emailed me, and I just happened to find the email. It was in my spam folder, and he was asking me, did I have a copy of the DOJ letter that had been rescinded back in December? And I said I did. I thought I had a letter because I put copies out. I had a hard copy. I don't know what happened. That was my fault. But I had my video that I made, and in the video I took pictures and put copies up on the video and everything, so I had it everywhere. And so I went to tell the gentleman that, yeah, I have the letter's gone. They deleted the letter like a day after he rescinded the letter, but I have this video, and in the video I have some references. So I went to go find my video, and it was gone. It was gone off the internet, for one. Then I looked at my website. It was gone off my website. It was gone off of Facebook. It was gone off of YouTube. Just deleted. So I looked at my computer to see if I could find a copy of the letter. It was gone off of my computer. Yeah. And the reason that how I have a copy of the letter now is that a friend of mine, a fellow advocate, had a copy on his computer. So he sent it to me, and that's how I have a copy of it now. Yes, I was pissed off. Violation of my First Amendment right to free speech has been violated. A couple of my computers have crashed since I started the child support hustle and been speaking out against child support, the unconstitutional child support system, but never has anything like this happen where something that I put out there has been completely erased from existence. So maybe this video will be erased, maybe not. I don't know, but I said I'm gonna put this information out again, just because it's so important. And again, it goes beyond child support. The war on the poor, you know, and we got to speak up for this. I don't know any rich people, and I've said that before. Hell, I'm not rich, so if I don't have money to get out of jail, I'm gonna be stuck there unless somebody's fighting to get me out, and that goes without saying. So we have to keep fighting, guys. Okay, so I'm gonna go over the 7 points of this letter. You can go look at this letter. The references are in the letter. I wrote a blog that's still up. I put it in the description of this live. So number one, courts must not incarcerate a person for non-payment of fines or fees without first conducting an indigency determination and establishing that the failure to pay was willful. So this transfers again over to child support. You cannot be incarcerated unless you willfully fail to pay. Now again, this is not, we know the system is unconstitutional, child support system. While we're fighting to get this system shut down, hopefully we can get it abolished. But in the meantime, people are still being incarcerated and having their rights violated. So this is in the meantime of while we're fighting. So please keep that in mind. And if I reference him or his in this, I'm just reading from the letter. Of course, we know that women are too violated in this system. So I'm just reading from what they say, but him, I'm saying him and her, okay? So I'm not disrespecting anybody or making it gender specific to just men, even though we know men in the child support system are disproportionately more affected than women. We know that. Okay, so the due process and equal protection principles of the 14th Amendment prohibit punishing a person for his poverty. And that was decided in a 1983 case, Bearden versus Georgia. Okay, so we shouldn't be punished because we're too poor to pay, period. So him rescinding that, Sessions rescinding that letter doesn't matter. This is what matters, what's in here, what's in the, that I'm going to read from this. So in that they had to incarcerate indigent people would deprive probationers, because we're talking about people that also have fines for maybe driving without a license, or any kind of fine that has to do with a ticket that someone may have gotten and they can't afford to pay. So that's why I'm reiterating that this goes beyond child support. This is for any ticket that somebody gets, any kind of punishment that's nonviolent, and they're being punished because they can't afford to pay the debt. Okay, I'm sorry. To incarcerate indigent people would deprive probationers of his conditional freedom simply because, through no fault of his own, he cannot pay the fine. That is illegal. And this is another case, Williams v. Illinois, holding that an indigent defendant cannot be imprisoned longer than the statutory maximum for failing to pay his fine. So when they're just holding people in prison or in jail because they can't come up with this money, and they do this all the time in child support cases, have them in prison or in jail because they can't pay the purge amount. That's unconstitutional and it's illegal. They can't do that. And I'm saying they can't do that. I know they continue to do that, and that's why we got to keep fighting. And if we don't do anything else in this child support system with the reform, we have to make them stop and end incarcerating people that can't afford to pay. That has got to stop. Before anything else, we have to end that. Okay, next part of this number one, we're still on number one. The Supreme Court held that in Turner versus Rogers, now this is in the letter, that a court violates due process when it finds a parent in civil contempt and jails the parent for failure to pay child support without first inquiring into the parent's ability to pay. If they're like, I posted today, Michigan did a sweep. I think Philly did a sweep. If those people the arresting officers or the judges did not do a hearing to determine ability to pay, they're violating all those people arrested. They're violating their right to due process. Okay, to comply with this constitutional guarantee, state and local courts must inquire as to a person's ability to pay prior to imposing incarceration for non-payment. E, under Bearden, that's the case Bearden versus Georgia, standards for indigency inquiries must ensure fair and accurate assessments of defendants' ability to pay. Okay. Due process requires that such standards include both notice to the defendant that ability to pay is a critical issue, and a meaningful opportunity for the defendant to be heard on the question of his or her financial circumstances. So it doesn't matter. All that was just a number one. It's all about ability to pay. So even though this letter is rescinded, that's the information that's in this letter. That's why my video was deleted. That's why this letter was deleted. That's why all this stuff was deleted. And that's why I had to say it again, because it's that important. Okay, the number two in this letter. Courts must consider alternatives to incarceration for indigent defendants unable to pay fines and fees. When individuals of limited means cannot satisfy their financial obligations, Bearden requires consideration of alternatives to imprisonment. That's those safeguards or probation. They have to find some other means to punish somebody and this is outside of the child support system, besides putting them in jail if they can't afford to pay. A payment plan, anything. That's not according to this letter, that's according to case law. Okay? These alternatives may include extending the time for payment, reducing the debt. Yeah, they can reduce the debt. Requiring the defendants to attend traffic or public safety classes, or imposing community service. Number 3, courts must not condition access to the judicial hearing or prepayment of fines or fees. This means state and local courts deprive indigent defendants of due process and equal protection if they condition access to the courts on payment of fines or fees. And this is the case Brody versus Connecticut, holding that due process bars states from conditioning access to compulsory judicial process on the payment of court fees by those unable to pay. Okay. Then we got Tucker versus City of Montgomery. This was back in 1976, holding that the conditioning of an appeal on payment of bond violates indigent prisoners' equal protection rights and has no place in our heritage of equal justice under law. Okay. I was going to do this in two parts because I know it's a lot of information, but it's really not that long. Well, it's kind of long, but it's so important. I hope so too, Ryan. Hey, Mary. Hey, T. Hey, Ezekiel. How's everybody doing? I thank y'all for listening to me. I was so upset, so I said I have to do this, just even if they delete it again. And I do believe we will get reform. I was talking to someone has commented on my personal page and said that, you know, they're discouraged and they don't think we're going to get reform. And I said, you know, I feel like that too. A lot of times I feel like giving up, but something like this happens and it pulls me back in like, no, you can't give up now. So we can't give up now. We've come a long way. We've come a long way, guys. So we just have to keep fighting and keep putting the information out there because, I mean, we have to. It's too important. There's too much to lose. We have to look at our kids and say, well, what if they were doing this to ours when they grow up and start having kids? Can you imagine? And we had an opportunity to do something about it. You know, I can't. So number 4, courts must provide meaningful notice and, in appropriate cases, counsel when enforcing fines and fees. Now, this is a big one because they addressed this in Turner versus Rogers, and they tried. Well, they didn't officially say that they are required to provide a lawyer. However, on the back end, they're supposed to provide a lawyer whenever incarceration is a possible punishment, whether the crime is criminal or civil. If a person can go to jail, they are supposed to have a lawyer represent them. And I'm gonna tell you in this. An elementary and fundamental requirement of due process in any proceeding, which is to be accorded finality, is notice reasonably calculated under all the circumstances. And I know this is a lot because I'm no lawyer. You guys know that. I'm just an advocate. So I'm just reading this word for word. Notice reasonably calculated under the circumstances to apprise interested parties of the pendency of the action and afford them the opportunity to present their objections. Okay, as far as Turner versus Rogers, discussing the importance of notice and proceeding to enforce a child support order, it states in part that the Supreme Court indicated that non-custodial parents charged with civil contempt must be given written notice that ability to pay will be a critical issue in the contempt proceeding. Title 4, a Title 4D case should include this notice provision in its contempt process. For example, a statement that the court will consider evidence of ability to pay. Constitutionality, adequate notice must be provided for even the most minor cases. So you don't have to be on trial for murder or anything like that for you to receive notification. That's your right. They can't just do whatever they want to do, and that's what they've been doing. And nobody wants to claim jurisdiction. And if you make a post or put it somewhere, anywhere else, you know, make sure, please use the hashtag who has jurisdiction, because we still want to know. They're doing all this locking up and sweeps on people all across the country without wanting to claim jurisdiction. State says they don't have it. Governor Kasich says he doesn't have it. The feds say they don't have it. Who has it? Y'all are illegally arresting people, illegally detaining people, and don't want to claim jurisdiction. Okay. Courts must ensure defendants' right to counsel in appropriate cases when enforcing fines and fees. Got a right to a lawyer. Even though the 14th Amendment, according to Turner v. Rogers, does not automatically require the state to provide counsel at civil contempt proceedings to an indigent non-custodial parent who is subject to a child support order, even if that individual faces incarceration. But the 6th Amendment requires that a defendant be provided the right to counsel in any criminal proceeding resulting in incarceration, and indeed forbids imposition of suspended jail sentence on a probationer who has not afforded a right to counsel when originally convicted and sentenced. Now I'm gonna have to get you guys the other part for the civil, if there is any part. If a defendant is facing any incarceration, no matter what, if it's criminal or civil, they have a right to an attorney. It's not on here. I should have looked it up before I did this, but I'm gonna get it to you. Okay. Okay. You see, although there is no automatic right, this is part of Turner versus Rogers. Although there is no automatic right to counsel in civil contempt proceedings for non-payment of child support, due process is violated when neither counsel nor adequate alternative procedural safeguards are provided to prevent incarceration for ability to pay. So they're not giving you any safeguards. Safeguards means something to show you that you can fill out a form to show your expenses and show that you cannot afford to pay. The child support office is supposed to provide you that before, if they don't give you a hearing, to determine your ability to pay before they put out an arrest warrant. That's when I say safeguards in my post, that's what I'm meaning. That's what I'm referring to. Hi, Mike. Hi, Maria. Hey, Eric. Okay. So now we are, let me see. Okay, courts must not use arrest warrants or license suspensions as a means of coercing the payment of court debts within individuals when individuals have not been afforded constitutionally adequate procedural protections. Say that 3 times real fast. The use of arrest warrants as a means of debt collections rather than a response of public safety needs creates unnecessary risk that individuals' constitutional rights will be violated. Warrants must not be issued for failure to pay without providing adequate notice to the defendant, a hearing where the defendant's ability to pay is assessed, and other basic procedural protections. When people are arrested and detained on these warrants, the issue is an unconstitutional deprivation of liberty. If a defendant's driver's license is suspended because of failure to pay a fine, such a suspension may be unlawful if the defendant was deprived of his due process right to establish ability to pay. See, the repeat ability to pay is repeated constantly. You cannot be jailed for not being able to pay a debt. That is a debtor's prison, outlawed in 1833. Why they continue to do this and nobody is saying anything is beyond me. In Bell versus Burson, holding that driver's licenses may become essential in the pursuit of a livelihood and thus are not to be taken away without that procedural due process required by the 14th Amendment. When they take your license away, they're depriving you your right to make a livelihood for yourself, to get to work, to make a way to live. I'm sorry, I get frustrated, and you guys know I do. Okay. Automatic license suspensions premised on determinations that fail to comport with Bearden and its progeny may violate due process. Due process rights, they violate all the time, and that's why I put in the description of this video so y'all can look up the link so y'all can tell when your rights are being violated and they say, oh, well, I don't know what you're talking about. You can say, well, here it is right here in black and white. Here's where you're violating my due process rights. And start making complaints on them. Or whoever's violating your rights, make a complaint. And keep complaining. Don't just make one complaint. Complain every day until somebody listens to you and fixes the issue. You have rights too. Just because you might not have any money does not mean you do not have rights. Okay, number 6, courts must not employ bail or bond practices that cause indigent defendants to remain incarcerated solely because they cannot afford to pay for their release. Back when they did this civil contempt, it was as a punishment. They often say, or they have it written, that the jailed can buy their freedom. They hold the keys to the lock to buy their freedom. So, oh, you refuse to, I don't know, you are an apartment owner. You own an apartment building and you don't, I don't know, paint the building and it's full of lead. You refuse to do it because you don't want to pay for it. So they hold you in contempt until you decide to do it. So you are in contempt and you can pay to get out, but you refuse to do it. You hold the keys with your money to buy your freedom. That's what contempt is. That's what the premise of it is for. But they've taken it to a whole different level. So now they're using it for all these other reasons. The reasons are unconstitutional. Okay. Any indigent defendants are arrested for, when indigent defendants are arrested for failure to make payments they cannot afford, they can be subjected to another independent violation of their rights. Prolonged detention due to unlawful bail and bond procedures. Any bail practices that result in incarceration based on poverty violate the 14th Amendment. Courts must safeguard against unconstitutional practices by court staff and private contractors. Okay, this is important. All this is important, but this is important because oftentimes in child support cases, there's not a judge that decides these cases. It's a magistrate or it's an administration personnel at the child support office. So that's what this number 7 is mainly talking about. Courts must safeguard against unconstitutional practices by court staff and private contractors. So, okay, so in many courts, especially those adjudicating minor and local offenses, the judge or magistrate must preside for only a few hours, may preside for only a few hours or days per week, while most of the business of the court is conducted by clerks or probation officers outside of court sessions. While most of the business of the court is conducted by clerks or probation officers outside of court sessions. As a result, clerks and other court staff and child support officers are sometimes tasked with conducting indigency inquiries, determining bond amounts, issuing arrest warrants, and other critical functions, often with only slight review by the judicial officer or no review at all. Without adequate judicial oversight, there is no reliable means of ensuring that these tasks are performed consistent with due process and equal protections. There's no oversight. And that's the same thing, no accountability. And that's the same thing with child support payments. There's no accountability. But with this, how are these arrest warrants, child support orders, all of this, how are they even legal when a judge isn't even signing it? These are workers. These are like welfare caseworkers. They don't have the authority to sign anything, let alone an arrest warrant. They don't have the right to suspend your license. They're county workers. They don't have a right to do anything, put you in jail. That's ridiculous. That's ridiculous. We gotta start calling them on this nonsense. A welfare caseworker signing an arrest warrant because you didn't pay something. That's what this is equivalent to. Y'all know that's okay. Regardless of the size of the docket of the limited court hours of the court, judges must ensure that the law is followed and preserve both the appearance of reality and fairness, generating the feeling so important to a popular government, and justice has been done. And they have a lot of sources for that. So that's the gist of what's in the letter, that the powers that be don't want you to hear, know, or see. And I appreciate everybody that tuned in. Of course, I'll post it so you can come back and look at it. If you didn't get to see it live, you can come back and look at it. Let me see if I can. Yes, Brian, they will deprive you your right to travel overseas. And the thing about those passports, there's no payment plan that you can set up. If you want your passport, you have to pay whatever you owe in arrears or whatever in full, or they won't bargain with you. They won't take a payment plan. They won't do anything. Pay it or you can't get your passport back, which is a whole other issue, especially when you have, which we know, child support. Even I don't care how many times people want to argue, child support is a welfare recovery program. So if welfare is involved at all, when you're paying this money, that's the government is who gets the money. The children don't get the money. And as soon as people stop arguing the fact, or feeling some type of way, or their pride is bruised because child support is welfare and they don't want to admit it, they'll understand that they're actually cheating their children. And another thing, all these supporters and cheerleaders for the child support system, with this letter, really, when it gets broken down, it goes beyond child support. This is a war on poor people. When you can go to jail because you can't afford to pay a fine, a fee, they can come and kick your door in because you didn't pay a ticket. That's our rights being violated. And I've said this from the beginning. They started with child support. Yes, they did. But it was going to go beyond that. As soon as people said, lock them up, punish him, lock him up, take his license, do whatever, he need to pay his child support. As soon as they said that was acceptable in society, they were going to come after other people that couldn't pay other government debt. And they've even went further than that. If you can't pay your credit card debts, they're locking you up in some states. Make no mistake, this is way bigger than child support. This is about being poor and being punished for it. So all the cheerleaders, and please don't hit my inbox with all that nonsense. I'm just not, I'm if you need to know more about what I'm talking about, y'all can go to my website. Y'all can go look through my post. There's lots of ways to find out what I'm talking about. I'm not talking about your individual situation. I don't know you individually. I'm talking about a system that was not designed, is not designed, and will never be designed for the best interest of children. No matter how you say it, no matter how you put it, no matter how you try to argue the point, the system is not designed for the best interest of children. And the more time that goes by, the more people arrested, the more people killed, the more people that die in jail over a little bit of money. Somebody just died. I didn't get his name. I don't think they released his name. He was in jail over a child support debt. He would probably still be alive had he not been in jail over a child support debt. This should bother everybody, whether they have a child support case or not. So I'm asking everybody, share this video and contact Attorney General Sessions, the White House, the Senate, Congress, your local representatives, and ask them, why did you rescind this letter? This letter is important. Why aren't you doing more? Who has jurisdiction? Why are you still arresting people if they can't afford to pay child support debt? When are y'all going to reform the system? There's so much that needs to be done. And we have to keep fighting. If not for our generation, for our kids' generation, for sure. I know y'all don't want y'all kids going through this. I sure don't want mine. So thanks for listening. I know that was long and some of the words I even struggle with. But let's keep fighting, y'all. And hope I see you in Memphis. And if you have any questions, comments, but watch the comments, please. Please try not to offend anybody, because y'all don't have to hear about it. I do. And come on. But it's a personal issue. I get it. And I'm just saying, I'm the one that has to hear about it. And I'm just going to start blocking people, because we up here trying to do something about the system. And like I said, it's not personal. I don't know you personally. This is about a violation of our civil rights, our constitutional rights, and we're tired of it. And if you need to get in touch with myself or anybody in the movement, you can leave an email at either DM us here, or you can reach me at contact@thechildsupporthustle.com. You can, don't forget to sign our petition. You can find it at thechildsupporthustle.com. Please share this video before it's deleted off the internet and our social media sites, as it has been once. But somebody on here on our Facebook page said must be doing something right if they did that. So let's keep going. Hopefully I'll see you in Memphis. And what else did I have to say? Oh, if you want to make a donation or buy a t-shirt or a book, you can do all that at thechildsupporthustle.com. I have the Child Support Hustle available as an ebook on Amazon. You can also get that at thechildsupporthustle.com. Our petition is available there. Everything is available there. We're on Instagram, Twitter. So there's all kinds of ways to contact us. If you want us to visit your city or state, let me know. We can come out. We're not going to personally do any more town halls, just because it's too hard to organize in different states. And as y'all know, I'm in Texas, and my team is scattered across the country. And it's just too much work to not have somebody there on the ground. So But if you want us to come to your event, just let us know ahead of time, and maybe we could set something up. Other than that, let me see. That's about it for me. Thank you for your time, and thanks for listening to me. Thank you, Brian. Thank you, Brian, for sharing. That was in South Carolina. That was Walter Scott. And he was running because he thought he was going to be arrested for a child support debt, and that cop shot him in the back. He got 20 years, I think. Yeah. So if there's nothing else, I appreciate you all. Keep fighting. Remember, they can ignore one, they can ignore hundreds, but they cannot ignore thousands. Let's go.